Subscribe to our YouTube channel and press the bell icon to get the latest updates.
So, first of all, thank you very much. I know this is a Saturday morning, and this is the appeal of the book and the author, that all of you are here. I'm particularly happy because one complaint I might have had with the legal profession is that most of you are now finding it so lucrative to make money by being lawyers or becoming powerful judges that our scholarship on law and justice had actually declined for some time. And that decline had begun to show also in the quality of writing, of not just on writing on law and judiciary in the larger debate, but also in the quality of judgments as well. So this is not something, I'm a journalist, I say nothing off the record. Everything I say, I write, it's in public domain. So I did say, in fact, in a period, say between 2009 and 2015 generally, that the quality of our Supreme Court judgments had declined to a level where some of it was embarrassing and some of it was, all this I've written. And you know, thank God for the broad shoulders that our judiciary has, that I've gotten away with it. But it was a bit like A says this, B says this, but I think this. So that is not the way to do judgments. Lately you've seen a great deal of improvement in the quality of writing, how cogently argued these judgments are. You can agree with them, you can disagree with them, but you can see a logical thread in them. So I think scholarship and judicial practice are both linked. It's very good, therefore, that we are having these books now that are bringing back some of these cases. Many of us quote these cases, Minerva Mills case, for example, Keshwanand Bharti, but a lot of people in the current generation don't know these in detail and don't know the import of this. So this is very important. Second, just a personal note. Since I've been around as a journalist for a very long time, there are moments when I really love my job. For example, I really loved my job when I was very young, but I got to write my first cover story for India Today in 1983 on Sunil Gavaskar, who was my childhood idol. Now suddenly to get to spend a week with him in Bombay and with his family to write this would not have happened if I was not a journalist. So this is one of those moments, because having been around a long time, I can also have journalistic relationships spanning generations. So when Justice Chandrachud, the senior Chandrachud retired, I was sent by India Today to do a pre-retirement interview with him. And I think it was a 4 or 5 page, very candid interview, including a question about why he had turned out a young woman lawyer who was wearing jeans in his court. And he said in that interview, I wasn't irritated by her jeans, but she had a comb sticking out of her back pocket, which I thought was inappropriate. And now I have the next two generations. The only other example that I quote, there are many other examples, the only other example in public debate like that I quote is that there was one day in the Indian Express when we had an interview with K. Subramaniam, an interview with Jai Shankar, who was then in the US, and an article from Dhruva, that is Jai Shankar's son. So we had all 3 generations featured at the same time. So once again, I'm very happy. And then I have Zia, who's been my friend. Every time a Baha'i gets hurt anywhere in the world, I'm among the people she calls. But she was very difficult to negotiate with at the other end when she was a tenant in our building in the Express. So I can tell you that she gives no quarter. Yeah. Justice Sikri, he doesn't know it, but you know, long before we had ever met or we had even come across each other or he even knew that I had anything to do with something, he gave justice to the Indian Express in a very problematic case as a judge. And that told us that there is justice in this country. And Madhavi, I wish there were more bright, brilliant, and doughty women like you in the legal profession. Balance is being restored a little bit, but much too slowly. So I'm hoping for when legal profession will become like our newsrooms. We are now looking for men to hire for the sake of some diversity. So thank you very much. And Justice Chandrachud, I know that you're used to lawyers praising you, so I have no such acts to grind with you. And if I do get, the only way I usually get hauled up at the Supreme Court level is when some reporter gets into trouble with something. And I think it happened a few times. And when that happens, and I have someone like Soli and Fali, behind whom we hide. So, and we usually get away with that. So thank you very much for being here. He introduced himself to me as I came in by saying, I am Chintan's father. So that is. I can talk about this and the law all the time, but nobody is here to listen to me any further. So if I may ask each one of you, there are 5 of you, if you could just take about 3 to 4 minutes giving your views on the book, and you start first.
Thanks, Shekhar, and good morning, everyone. I'm glad I have the opportunity to, at least following Shekhar, to lead this conversation rather than to follow the eminent legal stalwarts on my right. I thought it might be worthwhile to begin with what the impetus behind the book is. What's distinctive about legal scholarship in India is that a large amount of legal writing is now taking place in non-traditional sources. And what I mean by that is that it's taking place in newspaper op-eds, in periodicals, rather than in your blue-chip law journals and specialist journals. A large amount of this writing is sophisticated, but it's clearly intended to be addressed to a wider audience. So the purpose for which many lawyers, many judges, many of you in this audience today write op-eds is in order to include the wider public in the conversation. But some of the feedback that I got in my early years of writing editorials was that many of these editorials, these op-eds, are difficult to read and hard to access for those that are non-specialists, for those that don't have a background or training in the law. So the primary impetus behind the book was to write a book that does explicate some sophisticated legal argument, but in a manner that's accessible to a wider audience. The broader impetus really is in order to increase citizen engagement with the law and the Constitution. And I think this is particularly significant in the times in which we live, where the Constitution in general and the preamble in specific has assumed symbolic centrality across the country, and I think that's both because of Republic Day, the 71st year of the 71st Republic Day, as well as recent events in our country. There are 2 points that I'd like to note in relation to this book before I hand over back to Shekhar. The first is that the book deviates from the dominant narrative about the courts. I think the dominant narrative over the last 2 to 3 decades is that Parliament and the government violate rights, the matter is then handed to the court, and it's the court that then vindicates the position and protects citizens' rights. There are many examples in this book of courts have either abdicated their responsibility or not vindicated rights, and it's ultimately been left either to the public or to Parliament and the government to galvanize public opinion and to change the law. The second point I'd like to note is that we often hear, and we hear this in the media, we hear this in the press, that the court's decision is final. So the government can do what the Parliament passes a law, the government then enacts policy, executive action is taken, and it's ultimately for the court to decide the legality and the constitutionality of the issues before it. Now this can often be a rather simplistic picture of what is in fact far more messy. There's often a dialogue that takes place between all branches of government, and the court's decision is really often just part of the process rather than being a culmination of the process. And I think the important point to take away from this is that there is an important role for citizens to play, both in interpreting the laws and in particular the Constitution, at all stages of the process. Citizens' role does not begin and end before the matter enters Parliament. It doesn't begin and end before the matter enters the court, and it certainly doesn't end by the state at which the matter leaves the court. I'll leave it there. I'll hand it over back to you, Shekhar.
So I go to my right extreme and no recusals here. Chintan's dad. What is it that you find interesting in this book? And what is it that you find important? And what is it you disapprove of?
Well, before I answer that question, I must confess that there may be some ground for accusal if I were to actually write an opinion on the book. I have some shares in this company called Chintan Chandrachud. A little bit of the DNA and a little bit of the... Well, I think the most important thing today is something that Chintan began by highlighting, that there's an amazing amount of legal scholarship on the law, which is being written about by a hugely talented group of young people. Every Friday, I have presentations by my law interns once a week on some contemporary issue of law. And it's just a reminder. I mean, much of the presentation that I hear is very trenchant in its criticism about the courts and about the Supreme Courts. And I began by becoming very defensive about it. And then I realized, well, it's important that we open up ourselves to a dialogue with the wider society. And I think this is what this kind of legal scholarship really does, which Chintan's book attempts to do. Courts, I think the central theme of the book is this, that increasingly courts have not just become social institutions for the resolution of conflicting claims over private rights or over conflicting claims over public rights, but we have become institutions for social engagement. And that is why perhaps there is so much of critique about the courts and the work that the courts are doing. Because it's not really just about resolution of individual cases, but these institutions have now become focal points of a social dialogue. And if we look at this transformation which is taking place in the position of our courts today, particularly of the Supreme Court, I think that's when we realize the need for a greater engagement of the work of our courts, the constitutional courts, with the life of society. And I think partly because of the nature of the judicial role, we have been insulated from society. And I think that insulation is good insofar as your work is concerned as a judge, that nobody can call you up and tell you what to do. But equally, that insulation should not be taken to a point where the meaning of the work which courts do doesn't get transformed into the lives of society. So the book is not really just a book for lawyers, for judges. It's written in a very simple style. And the idea of these books, there have been a host of books which have come in through the last year. You have Gautam Bhatia's Transformative Constitution. You have Rohit Dey's The People's Constitution. Madhav Khosla has recently written on the foundational document. So a whole lot of books of this genre which have come into the public arena, I think continuously remind us of course the dialogical role which courts play. And it's dialogical and fortunately not diabolical. But it's because of the dialogical role that we play which opens us up to this social dialogue as a part of this wider constitutional socio-political institution. And I think that's the theme of the book.
So, Justice Sikri, pick up the thread from there, but also going to the question of is higher judiciary accessible in terms of understanding to common people or not? Or has it become less esoteric and less accessible, or more esoteric and more inaccessible?
I think the answer to this question would be yes and no, both. If you see it from the public's point of view, the way people and particularly the common people think about the judiciary. I remember in England, there was one, I read it because this was a book, it is called Like We Have Our Judicial Academies. They have a justice study board. Now it is changed to some judicial college, the nomenclature has changed. And they had done some research many years ago and had asked people about what is your perception about the judiciary. And the phrases or the adjectives which was used were daunting, intimidating, and very hard to go to the court, and the experience is really traumatic. So when it comes to access to justice, insofar as many times many people they think that, look, if we have some cause which we have to bring it to the court, it is not easy job. That may be largely the feeling. But at the same time, I would say, that is why I said in the beginning, yes and no both, that things have changed in last 20, 30 years, or maybe 40 years ago when I joined the profession. There have been a lot of reforms in this behalf, that how to give access to justice. Not only the courts have taken many steps, even the government has taken steps, and towards legal aid, etc. Now, that is my response, but I will say something about the book as well, as that was the question which was asked. Apart from what son and father has said about this book, of course, Chintan knows more. He is the author, he is the father of the book, so therefore he knows about his child more than anybody else. What I found was, first, my comment would be, it supplements and complements Zia's book, the 10 judgments which changed India. And the 4 topics which are chosen, politics, gender issues, religion, and national security. I admire for that, because these are the issues which remain valid even today, and it will remain valid for all times to come. And these are more relevant today in today's times, what is happening in this country. And another thing which he said was that, look, on such issues, Supreme Court keeps giving, or even the High Courts, they keep delivering the judgments, and they have far-reaching implications insofar as the general public is concerned. But public should know what the Supreme Court or the High Courts have decided in these judgments, and therefore it should not be in a legalistic manner that it should be, and that is what this book aims to achieve. And the storytelling method which he has adopted, it's just like you are reading a novel. And it is not confined, he himself said, it is not confined to what the Supreme Court decided, but then he says, even before the case lands up in the court, a particular case, which 10 cases he has discussed, what happened before that, what happened during the proceedings, and what happened even after the judgment, and how there was debate in public, and the kind of research which he has done, finding out those debates which appeared in the newspapers, in magazines, etc. It is really, really very admiring. But more than that, as well as my one comment would be that the book gives this message as well in respect of these 4 topics which I have told, that the judgments were given, 10 judgments which he has chosen. These topics keep arising even today, whether anything has changed during this period, or like a judgment as well as politics on that judgment, which you have said, that relationship between the, in Shekhar Singh case, judiciary and the executive, what is the position today? Which, when you said that Mathura case, what was the psyche of the judiciary at that time, whether anything has changed till date. So these are really, really some of the aspects which need a lot of introspection and lot of debate. And that is the debate which this book should and would generate.
Thank you very much. See, I asked you about accessibility. Now, personally, I was more interested in the section on national security, because on many of those cases, I as a reporter was in the other end of the spectrum, because I was seeing what was happening as a result of terrorism on the ground. So I might have seen it differently from how you might see it in Delhi, when you are immune from all of that. So, Madhavi, you talk about the book, but let me also ask you, do you sometimes get the feeling that people who decide on these things, say in Delhi or wherever, you are far away from where the action is? They don't quite always understand what's happening. So, just to elaborate in half a minute, if in a terrorist situation, terrorists kill judges who try them, they kill witnesses who dare to depose against them, they kill public prosecutors who dare to stand against them, they kill journalists and newspaper owners who dare to write about them. Then they say, give me the due process of law. Isn't that classical chutzpah, that I kill my parents but take pity on me because I am an orphan?
Thanks for that, Shekhar. I'll just say something about the book to start with. Well, I like the quote you start with, which is from, well, it's Isaac Newton, I didn't know that. If I have seen further, it is by standing upon the shoulders of giants. You couldn't have been more apt there, because I think what is really unique, Chintan, apart from your scholarship, is the fact that you have this unique vantage point, being a third generation legal scholar and lawyer. And the vantage point you have, and which you used very well, I think, in the book, because there are so many interesting nuggets and anecdotes and backstage stories which you weave into each of the judgments you dealt with. And it's really interesting that, you know, it's difficult to divorce it in some ways from the story of your own family, because I think a lot of those judgments, that does come through, and I think that makes it very, very interesting. Of course, you know, the exchanges between Justice DY Chandrachud and Justice Bhagwati, and you know, Justice DY Chandrachud's dealing with Narsumali Appa quite recently. I saw a mention of Dr. Chitle's arguments in one of those cases. So I think it's a really unique vantage point, apart from which, of course, it's very, these are really stories about a young republic and the issues which have troubled us through the years, whether it's national security, gender justice, caste, and all of that. But I think it's a real service to the access of to justice, to demystify the court for lay people, and sometimes even for lawyers, because very frankly, sometimes now lawyers find it difficult to read, say, a 1,000-page judgment, or, you know, so many judgments are, you know, one single judgment may have, you know, there are 5 opinions, so it's really difficult to access. So it's important that young scholars are demystifying it for people, and as I said, it's an important facet of the access to justice. Shekhar is right that actually for many years, young lawyers or even other lawyers didn't write at all. Virtually nothing really came out for years and years, and now suddenly we find this huge you know, efflorescence of writing, and very good writing, which is wonderful. For me, actually, the winner was, amongst all those cases, all of which are very interesting, but the winner was Rupan Deol Bajaj. And it's interesting because while I was growing up, I think I did read a lot of reports on this case. But really, when you put it down together, I think she's the real hero of your book, in my view, because, you know, for a woman of, well, she was a powerful woman, she was a bureaucrat, but for her to have withstood that struggle for however, I mean, years and years of going back and forth between courts, and it must have been very emotionally draining. It must have required huge financial stamina, emotional stamina, but the fact that she saw it through to its logical conclusion was very, very important. And the fact, I think, which you capture very well, that the media of the time portrays KPS Gill as a naughty hero. The fact that he was a national hero because he had, you know, put down militancy in Punjab, but the fact is that, you know, he shouldn't have got away, and the fact that very liberal leading newspapers of the time, or a leading woman journalist, condemns her for having gone after him because he is this great national hero. So I think you capture that very, very well. And one more thing, of course, you mentioned national security. I think, yeah, you're right, Shekhar, that sometimes the courts are divorced from, and it is very difficult, as you rightly say, sitting in Delhi to really understand what is going on in the Northeast and to be really sensitized to. But that is, in some ways, our court it's in Delhi, but it really takes decisions which impact the lives of effectively 1/6 of the human race on a very, very wide range of issues, and which is why perhaps in NJAC the argument was raised, do we need so-called, they were called eminent persons to be able to, have a say in seeing whether judges are not just, selected by judges alone with, legal knowledge, but it's also, are they active, are they sensitive to society as a whole? So that was an important issue, and I think you're right there. But one more thing, just before I quickly hand this back, you mentioned doughty women. I think this morning would be incomplete without a mention of a very, very doughty woman who would have been very proud today. Rashmi would have been enormously proud today, and I think it's very important.
Accessibility we started with. Now, I will tell you something. I go and speak at lots of colleges, schools, lots of very high-profile colleges and schools. And what shocks me, what surprises me, shocks me, amuses me, or maybe scares me, is just the lack of awareness of what the Constitution is. Everybody mentions the Constitution as a mantra. Cow slaughter. The Constitution orders the government to stop cow slaughter. Then that is on the right. On the left, somebody says, but the Constitution orders the government of the day to provide housing to all. And I ask for a show of hands, most people don't know the difference between the directive principles and the rest. So in fact, it's for that reason, Zia, that we've now started a new 1-minute series on Instagram, 60 seconds, every day to know one aspect of the Constitution. And what do we call it? We call it KYC, Know Your Constitution. Just as a bank calls you and the person who does it is sitting right there, Apurva, just stand up and say, so, Apurva Mandhani, she's a lawyer. She's been putting it together every day. So, when an ordinary person goes to court, an ordinary person, the trial stage does not have a lawyer like you or Madhavi. Doesn't have a judge like him, doesn't have, or many others, doesn't have a scholar like him to analyze those orders. But what gets written at the trial stage is what lasts. Because again, most people don't realize that unlike in the movies, no fresh evidence comes in appeal courts. So unless you reform that, I mean, talk about the book, but also unless you reform that, because I have faced that many times, and for me it's an amusing story. As my old friend Robert Blackwell used to say, no matter how bad the times, tomorrow they'll be your good old days. So it's always stories for tomorrow. So I've been in courts where the same lawyer writes both side statements. And I've also been to courts where 5 different witnesses are, in different cases, are recording their statements at the same time. So that is the lived experience of the average Indian. Because the average Indian is not like one of your clients.
Good thing, thank you. I think that, first let me just give a little bit of what I'm feeling today. I'm feeling very emotional, and I can't believe that young Chintan is now Dr. Chandrachud. Get ready, Danny. And this book is really special. I was reading it up again on the flight, and I realized that Chintan has reached the epic of storytelling. I remember when Chintan virtually wrote my book, Justice Sikri, just so that you know, Shobha Day came and said, darling, you just have to write this book. And I said, I have no time to write any book, Shobha. She said, no, you just have to. We've decided and you will write it. So I looked at Chintan and I said, will you write it? So he said, I can't write a book. I said, well, do the most of it. So Chintan, as you say, Justice Sikri, really went back into what compelled AKs to come to the stage that it did. the cases that went before them to reach where the Supreme Court decided, and really whether the Supreme Court later on reviewed, ignored, winked, turned a bit of a blind eye, or what the government did in response to the case. I think really the fascination of this book is the storytelling part of it, so well researched. And it makes you think. I mean, when Chintan says the Supreme Court failed Mathura, you wonder where the Supreme Court will be today, and we look to some of our stalwarts there to make sure that they don't forget Mathura. But there are so many historical stories that we forget. And there are so many wonderful interjections. So when you say that, your hero is who she is, I thought of Indu Jai Singh, who was busy defending her. And, I think that she must have provided a lot of soul food for her to sustain in these difficult times. And then when you see the Sarkar case, and you see Ashok Desai out there pulling his punches, and we have in this audience people without whom many of these cases, Chintan, may not have reached the stage where they are. My father, Fali, KK, just to name a few. And I think what really touched me about this book was Chintan's legacy. As you say, he is happy that his grandfather took the opportunity in Minerva Mills. He also says his grandfather lost the opportunity to review the case that Upendra Bakshi asked him to. And I think it's a wonderful story of a family that has survived many generations of legal scholarship. I think in terms of your point, Shekhar, the reality is the reality. We cannot deal with the access to justice, which allows a lot of us to approach the court, with the corresponding problem of the lack of judges, the continuing education of these judges. And the hope is that just like in the Minerva Mills case, where it was just simply about a bank being nationalized, got woven into a very different story by the people who ultimately argued it, by Mr. Palkiwala, where the first case of Chintan's, where it was a rowdy pamphlet clearing judgment case, which then ultimately led to a clash between the institutions. So I can say I don't think there's an eternal solution, but I do think there's an eternal hope. And I think what Chintan's book does is he reminds us of the forgotten failures as also for the forgotten successes. So well done.
Madhavi raised the eminent persons issue, who appoints judges. So this question keeps coming up in my mind also, that when a judge is appointed, now the Collegium appoints a judge, you can call it transparent, you can call it autonomous, you can call it whatever. But the fact is that different countries appoint judges in different ways. See, for example, say in the American system, every judge, every appointment is a political appointment. And then you have, you analyze at congressional hearings, you analyze all that the judge has said or spoken, not necessarily the Kavanaugh case, that's one of a kind. But the judge's judicial record. Do you think, any of you can hold forth on this, or maybe each one of you should speak for half a minute. Does India need that kind of scrutiny now before appointing judges? And I will, once again, I'll be a journalist and I will tell you. When a High Court judge gives an order saying that peahen gets pregnant by licking the tears of whatever, peacock's eyes, or the other way around, I don't know. Or when a Himachal High Court judge writes an order which the Supreme Court of India says we can't understand, so we are sending it back. Is there any scrutiny in terms of what all he has done until now? Or we have one particular judge right now, I'm even afraid to name him, although he's no longer a judge, who's now a social media hero. And every time he puts stuff on social media and his views, you wonder what kind of orders he's been giving all his life. I mean, he was called the liberal lion of the bench. So, do Indian judges also need greater scrutiny for what they have done, not in their personal lives, but what they have done as judges earlier on. So, sir, if I may start with you and go like this.
Well, I start with the postulate, of course, that the Collegium system of appointing judges has been held to be constitutional. So I proceed on that hypothesis, which is the law as it stands. How do you improve upon the Collegium? You've referred to aberrations, and of course there are aberrations. But you must also look, I think, Shekhar, at the wide mainstream of judges. Now, how do we improve on the system? I think there are a couple of areas where we need to bring about change. We do have established patterns for assessing the work which, say, a district judge does before she is appointed as a judge of the High Court. You have a judgments review committee. You have confidential records, the ACRs of the judge which are evaluated. You have a general assessment by the administrative judges. Now, there are a couple of things which I think we need to bring about. One, the need to bring about a greater sense of diversity within the judiciary. Now, it's easier said than done for the simple reason, I'll give you an example. When I was Chief Justice of the Allahabad High Court, one of the things you always get letters from the Chief Justice of India, from the Law Minister, that please do improve upon the diversity of the judiciary. Now, in many states like Uttar Pradesh, where women's education began much later than, say, Maharashtra or Rajasthan, or for that matter, Delhi. Delhi is a prime example. You have so many more women in the district judiciary. Many states in India were, in that sense, there have been asymmetries in terms of the growth and development of women's education, which reflects on the number of women at the bar. Now, unlike the American system, for instance, where you can pick up somebody from public life and ask her to become a judge of the Supreme Court, we don't, except for the eminent jurist category, have that liberty under our constitution. So one area where I think we need to do some work is to bring about a greater sense of diversity within the judiciary. And that sense of diversity you can bring about, and I've spoken about this in one of my recent judgments in the Roger Matthew case, the tribunal's case, that it's important that our collegium lays down for wider society the standards which we apply in the selection of judges. For instance, when we appoint judges of the Supreme Court, should we not have a judgments review committee which will review the judgments of our High Court judges before they are assessed for appointment to the Supreme Court? Will we not assess the quality of the judgments which have been delivered, the number of important cases that a judge has decided? So I think laying down transparent norms on the basis of which we will assess individuals for higher judicial office would be one very important step which we can take towards making the collegium system of appointment more transparent. That's certainly something which we need to do.
So let me take this in sequence, and starting with you, yes or no. Do you think it's time now for Indian judiciary to open itself out, at least to full-time academics on law and justice, to come into the judiciary?
Well, the Constitution does provide for that sort of a situation.
But it hasn't been happening very much.
It hasn't happened in the past. I know, not even once.
Not even once.
I know that, one or two people came very, very close to being elevated as judges of the Supreme Court. But another thing which we should do, I think, is that we look upon judgeship as a sort of a career choice, a lifetime choice. We always joke that once you're a judge, you're always a judge for the rest of your life. I think we need to think out of the box. Why can't we bring into the judiciary people who will come in for shorter periods?
And go back to
And go back. You are doing that now in government. You have lateral entry into the government at very senior levels. Why do we have to believe that, well, you will recruit a judge as a district judge at the age of 20, or as a civil judge junior division at the age of 25? That person will continue all the way to 62 or 65. Why don't we think of bringing in lawyers, for instance, on short-term appointments to the High Court, say 5 years? So the lawyer who, say, a top lawyer from the Delhi High Court who hasn't become a career judge will come in at the age of 50, work not in the Delhi High Court, work in the Bombay High Court, work in, say, the Gujarat High Court, work for 5 years and then go back to the
see the picture from both sides. So Zia and Madhavi, you are people with lucrative legal practices. Will you make that supreme sacrifice for the nation and work on a government salary for 5 years? Zia, I know her answer.
I don't fall into that category of a lucrative practice. My only client at the moment is the government.
Not at this point. Zia?
I think this was a proposal, Denny, a while ago, to allow people from the bar to become short-term judges. I think the UK has such a system.
Yes.
And I think it didn't get passed by the judiciary and probably the government because being who we are constantly thinking of conflicts of interest and other agendas and, what will that person do if he's going back, will he have... So I agree with this suggestion. Would people sacrifice a few years of their life? Most likely. Because a lot of people who are successful acknowledge that the success doesn't come for themselves alone. And a lot of them are willing to give back a certain period of time to what they believe is the greater good. It's like private practitioners are open to joining SEBI on a revolving door basis, provided they have access to the real world again outside. So I think it's something, if you believe, should be pushed as part of your agenda to have a more robust and more bustling roster on a short-term basis. You should definitely relook at that. It was mooted about 15 years ago, I think.
So you think it's a good idea? Because, sometimes do you think the judges or the judiciary self-flagellates or confines itself into a bunker too easily? Look at the lawyers who become law ministers. They become law ministers, they are full-time politicians, but they're in power, they become ministers. They go back, they become lawyers, then they are practicing the courts of the same judges that they might have been party to appointing, or they might have been party to not allowing the elevation of. So if the political class can handle it, and you can accept it on the political class, then why deny it to your own community, professional community?
I think on that everybody would be unanimous that it's a good, brilliant idea. And I remember Zia, when she was saying that it was mooted here, Soli, Wali, and even I think KK, they offered. Am I right, sir? I think they offered at one particular point of time, 15 years ago or 20 years ago, that we are ready to come for 2 years, 3 years and go back. So if, and at those times the practice was at the peak. And only thing is, and maybe it's, I would say that a very, the thought process may not be correct, and the main problem was conflict of interest, which can be taken care of, and the things can be started at least at High Court level, the way Justice Chandrachud suggested, that from Delhi a person can go to Gujarat or Bombay and then come back. So the conflict of interest situation would not be there. As far as collegium system is concerned, of course, Justice Chandrachud, very rightly, because he's still a sitting judge, and he said that since there is a judgment, he'll proceed on that presumption. But I am not a sitting judge any longer, so I can say that it needs reconsideration as far as this system is concerned, and whether India is the only country where judges appoint judges. That is one. Then presuming, actually maybe on papers and going by Indian conditions, it may be one of the best even today. But in its working, again, Dhananjay in a very subtle manner accepted the fact that the collegium system may not be working that efficiently today, and it needs changes. He has said in 2 judgments, one judgment which he quoted, and other judgment, he and Justice Sanjeev Khanna was sitting there, on where CGI is now, office is subject to RTI. There also lot is said about, of course it was in the context of whether when this process is undertaken for appointment of judges, whether it should be made public, etc. or not, and public interest on the one side and the right to get information on the other side. In the whole process, both of them have discussed. At the end of the day, let me be very frank and blunt by saying so. What Shekhar, you said about that, how we get to know about the, as far as a particular judge is concerned, from High Court to Supreme Court if he has to come or she has to come, or from District Court to High Court. As Dhananjay also said that, yeah, we have the process of evaluating their judgments, etc. But still, I would say most of the time we go by our impressions. It may not be a scientific study made about a particular candidate, if the candidate is chosen from the bar or from the bench when it comes to Supreme Court. And the Collegium goes by this, and therefore many times those may be aggressions. Those who are taken, they may not be deserving, and many times those who are deserving are left out. So that needs to be taken care of, and something has to be done.
I think I think we've got onto a very healthy track. So,
Can I just add something?
Sure.
Yeah. I think given the aberration, given the constraints of the system, the cases which you mentioned at the start were, I think, aberrations. I think given the constraints we really do have, it's amazing how the system does throw up a lot of very excellent judges who are willing to give up lucrative practices to be in judgeship. So I think that is important also to acknowledge, while also acknowledging the fact that I think we do need some, given the range of issues that the court is deciding, particularly our higher courts, we do need some kind of, just having judges or just being a great lawyer is not necessarily going to make a good judge. So when you have issues like 377 or environmental issues or issues which, a lawyer may not have, the legal knowledge alone is not enough. You need a lot more social sensitivity. And therefore, I think the system has got to be able to pick up people who may be able to assess, as to whether a person has a good sort of social sense, a breadth of experience outside of the courts. That's important in our system particularly. And when we talk of diversity, I think, particularly when it comes to women, it's interesting that a couple of weeks ago, I met a senior counsel, a woman, who mentioned that she had missed out on judgeship because she spent the first several years, being a stay-home mom because she wanted to be with her child. And then by the time she got into practice and did very well for herself, it was just too late. So should the age be the same for men and women if women have families? How are you going to take care of that? And we may be missing out on some very good candidates because we don't take that into account.
It's a very valid argument, so I will use the opportunity also to slip in my consistent opinion for a long time that 62, 65 is too early for judges to retire. That, just as IIT professors serve till 70 now, that's, this is the post-statin era. Our arteries stay cleaner much longer. So people should, particularly people who have attained that level of eminence and experience should serve much longer. So Chintan, the other big change on the Indian legal scenario, and I think that is what is resulting also in better quality judgments now, better judgments with greater clarity, is how legal education is improved. The rise of national law schools, and in their wake, just as the IITs then set the bar someplace and then many engineering colleges rose, a lot of good legal education is now happening. So how much of a contribution is that making to this change right now? Because even journalistically, we look at a judgment and we make up our minds very quickly because we find it forbidding to read judgments. Now, Sabrimala judgment is an example. The moment Sabrimala came out, everybody said, oh, what a strange judgment that all the men have voted on one side and the woman judge has voted on the other side. But it's only when you read her order, dissenting order, I just thought this was one of the most beautifully argued judgments because she was not looking at it in gender sense. She was looking at it in the sense of, tu kaun mein kham kha, what's your problem, right? You are an interloper. And the point was that then anybody will then muscle his or her way into any other faith's issues and there'll be a free-for-all. It was a very well argued judgment, but most of us normally would not have read it. So I was privileged because I had young law graduates who are now working as journalists who could point this out to me. But you think we are now seeing that change? We're seeing scholarship come back into judicial practice?
So Shekhar, before I get to that, I will respond to your question. But before I get to that, I can't resist but comment very briefly on the NJSC and take off from where Justice Sikri left it. And I should emphasize that this is my personal opinion. It shouldn't be attributed to anyone in the family. But my view is that a large number of both sitting and retired judges had taken the view that the Collegium system simply wasn't working. And the best demonstration of this was that many leading advocates were refusing to take up judgeship, and many leading High Court judges were not being elevated to the Supreme Court. And I think there are two important things that we need to remember about the NJSC. One is that it was the product of a bipartisan consensus. Remember, this was not one of those statutes where the opposition staged the walkout or where the majority tried to push through parliament. The second is that it's also interesting to think about the fact that the court didn't give an opportunity for the NJSC to play out in practice. And if you consider many of these the judgments that I look at in the book, for instance, take the national security cases. There is a gap of a decade, often 2 or even 3 decades, between the legislation coming into effect and the legislation being challenged and the challenge being considered by the court. Now, what's the benefit of that? The benefit of that is that you not only have the experience of what the law says, but you have the lived experience of how the law has operated in practice. So I think the court may well have chosen to do one of two things. To one, give it an opportunity to play out in practice and see how things transpire. And second, there could have been some amount of remedial creativity. I mean, typically we always assume that the court just has two options, uphold or strike down. But in practice, really there's a spectrum of options available to the court, and it can strike down with reservations, uphold with reservations, and the like. Coming to your question, Shekhar, the national law schools, the emergence of the national law schools has undoubtedly made a difference to the availability of solid legal scholarship in India. And you see this being reflected in the judgments as well. Because it was very common until perhaps even 10 years ago for Indian Supreme Court judgments either not to engage with scholarship at all or to engage with scholarship predominantly from overseas. I think that's now beginning to change because you often have judgments that are engaging not only with international and foreign scholarship, but also with domestic scholarship. I still think that there's somewhat of a problem here, which is that not enough of the best candidates are being attracted to academia within India. So a lot of the finest scholarship about India is still being written from abroad, from foreign universities. And as they say, there's an old saying that the Indian Law Journal, as opposed to the blue chip foreign law journal, is the graveyard for all Indian scholarship. You put it there and it dies a slow death. So there are some things that need to change, but at least the direction of travel is right.
Well, thank you very much. That's very nice. Now I'll ask. We just have about 3 or 4 minutes left, and I know we've been very punctual here. So if each one of you could mention in the last 10 years, when some Chintan Chandrachud writes a book like this 10 years from now or 20 years from now, the cases that you think from these last 10 years that will find mention, I know there are a couple already here, but other cases besides these. So 1, 2, 3, 4, whatever, so you first. These are done cases.
Cases which have been
completed.
Why mention in
a book like this in future, but from this decade, from the 2009-2019 decade.
I think, Shekhar, the cases, I won't mention a particular case, but I think the cases which we'll really be thinking of are cases of the outliers. I think it's important that we focus on the cases which said, hey guys, there is a different perspective on the problem which you are addressing. Because I think the true value of the nation as it goes forward, I think today, is for us to accept that this is a nation of plural views. It's a nation of plural identities. It's a nation of a multitude of cultures. And it is really in this in this conflict of intellectual opinion, of a multitude of cultures, of identities, of thoughts, of process, that the true India which I perceive for the next 10 years should emerge. So we ought to really be valuing judges who constantly tell you that while we respect what has been laid down by our colleagues and which is today the prevalent view, judges who have said that I think we need to do things differently. I think that's where I would look to the future.
Madhavi?
Well, I think we've had so many very interesting and path-breaking judgments in the last even 2 or 3 years. So I think,
Any problematic ones that you might think need a dissection later or a debate? No, I'm not saying that in a judgmental sense.
Well, we are it's a court which doesn't necessarily speak in one voice. That we must acknowledge. So we don't know. It's hard to predict what's going to happen. Sabrimala is going to be heard again shortly. So that is going to be an exciting one. Of course, Ram Mandir, Triple Talaq, these are really matters of moment. 377. I think these are real epoch-making judgments at a certain level.
Sir, and let me also add one more question, which is that, say, in a country where judges' appointments are political, like say America, you know how a judge or how a Supreme Court will rule on a certain issue. But in India, do we find sometimes seasonal shifts on largely social issues? For example, if you see the earlier judgment of 370, then you see the judgment of Haryana Panchayats, exclusion of those below matriculates, and third, the judgment on the appointment of priests in Tamil Nadu temples. Now, one judgment has been overturned within a few years, within 3 years or 4 years. Other two, I suspect, in the course of time will be questioned. So, do you find a kind of a flavor of this season in the way Supreme Court speaks out on these issues?
I think it has always been there. That is one lesson which we learn from the book which is authored by Chintan, and we are doing Chintan about that. And today in this, there would be, one trend is there, as we know the society change, societal norms change, and therefore the Supreme Court is, or even the High Courts, are much more liberal in their approach towards these rights of the people, and when it comes to what was the position about 20-30 years ago. At the same time, it all again depends upon, as it is said, if there are 14 benches in the Supreme Court, there are 14 Supreme Courts. So it would depend upon, and that is one reason if you see what is happening when, which you rightly commented, a particular judgment delivered today, even within 1 week or 10 days, either in a review or otherwise, it would be referred to larger bench, that issues. And two cases which are pending here, which it said that Sabrimala case is there, Aadhaar on one money bill is again referred to the 7-judge bench, and let us see what happens. And what I feel is that as Madhavi rightly pointed out, in last 3-4 years, many path-breaking judgments have been given. And if we add to the list of Zia's book, then it may be right to privacy is one judgment which would find the cases which which shaped the nation, and even this 377 judgment would be those, and in forgotten judgment maybe those judgment making this adultery, decriminalizing the adultery is one judgment which should be referred to and which would be discussed. Yes, as far as issues in Sabrimala are concerned, they may be debated and discussed irrespective of whatever 7-judge bench also says for a long time to come.
Zia, which cases, besides the ones that you have listed and he's listed?
So, very quickly, I think that, what I would be looking for the Supreme Court to do was to take every available opportunity to look at the gender biases and to use their jurisprudence to reshape thinking genuinely on the judiciary and therefore the citizenry at large. I think if we still look at what we have today, there is an unconscious bias. And how do we really change that? That is something that I would look forward to in the next 10 years. The trend has started. Danny always says she, but Danny is only one of very few. So the next thing that I would see is, our educational institutions, as you should say, Shekhar. The reservation issue is a constant struggle. Competence versus capacity building. How do we really draw the balance if we are to become a nation which gives access to students of competence? That is one. And then the last one I would say is national security, which is close to your heart. Chintan's cases talk about whether national security is a theme where the judges freeze a bit, go into chill mode, and government uses it as a get out of jail card for them. I think I would like to see in the next 10 years that balance becoming better. So if you look at the Tata case, ultimately it just died a natural death, not because of the Supreme Court, but it had outlived its 10 years. So how is that dialogue going to really come out in the future? We are a democracy.
Chintan, your next one.
So I can think of two sequels to this book. One of them is The Cases That India Forgot, Part 2, in a decade from now. And the other is The Cases That India Forgot to Decide. And let me start with the first one is, and my concern is, that the right to privacy judgment, which is perhaps the most significant, the most canonical judgment over the last decade, will be forgotten and will not be implemented in spirit. And the right to privacy judgment is one of those unique cases where everything is at stake. It's whether a fundamental right to privacy exists, but also on the other hand, nothing is at stake because there's no issue or list for the court to decide. And my concern is that the lofty principles and significant principles articulated in the court's judgment will not be applied robustly in practice. So it's one thing to articulate principles of the highest order, it's quite another to apply them robustly in practice. So that's the fear that I have. The other sequel could also be The Cases That India Forgot to Decide. And this is really a matter of priorities. Now remember, our court is like no other Supreme Court in the world. India's Supreme Court decides more cases in one day than the UK Supreme Court decides in the whole year. What that means is that there's naturally a queue, and some cases are more important than others and are heard before others. What this results in is that significant cases are often simply not decided, are simply not determined until it's too late and you reach a situation where the issue is irremediable. And so therefore I think this idea of judicial avoidance is also something we need to think about. And the good and bad decisions that the court has taken also need to be considered in tandem with the decisions the court has simply avoided.
Well, thank you very much. We can go on for a long time, but I think we have to conclude this. Now, before I conclude, a couple of quick observations. First, NJAC. You mentioned NJAC, and I did write at that point that I'll be very suspicious of a law which gets passed so quickly in our parliament. Because our political system gets Victor Hugo upside down, which means he said nobody can stop an idea whose time has come. Our political system, nobody can stop a bad idea whose time has come. So a parliament which can pass almost no law without fighting, screaming, shouting, walkouts, when they pass a law without any debate unanimously in 24 hours, you know that there is trouble. And that in my mind plants the seed of suspicion. That's one. The second thing is, you talked about a season when lawyers' practices are very lucrative. I have a different view on that in the sense of on the season. I think the season when legal practice became truly lucrative was the so-called fight against corruption season. That is the 2009 to 2015-16. I call it the Bentley season of legal practice. And it's a couple of judgments from that period which I would like to see some Chintan or Chintan himself talk about in the future. The 2G judgment, the coal judgment, the economic consequences of which are quite complicated even now. And once those are done like that, this is a weapon of mass destruction. It's a WMD, you can't fight it because it's now there. No bureaucrat will question it, no politician would question it. So these are things that have had a long-lasting effect. So those are things that should be debated. And the third thing, Fali Nariman has gone. He paid you a great compliment by saying that you have the clarity of Lord Denning. So on behalf of us journalists, I have a small request that when you deliver a judgment, or even when you have 5 different five judges on one bench, give us what we journalists call a nut graph. Give us a para saying what this means. Now and you can make sure that that is not binding. A lawyer cannot go to the court tomorrow and say you said this in the nut graph. But please idiot-proof it for us journalists, because sometimes you delve into it, it becomes a little forbidding. So, and then you miss these subtleties and arguments as we might have in that Sabrimala dissent. So I think on that note, Chintan, congratulations. Thank you very much, and thank you all.